Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 61st lecture, and we are going to discuss about a very important judgment, a landmark judgment. But it is our regular practice that before dealing with the subject or before dealing with the topic, it is our regular practice that we recite preamble of the Constitution of India. It is reminding oneself that we need to achieve those goals enshrined in the preamble. And being the lawyer in the apex court, you should know the values of the preamble, and you are the creamy layer of the lawyers community is. So we have to set a role model, and we have to follow the goals, what is enshrined in the preamble, and we should recite every day as a daily prayer. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, as I said, this is our 61st lecture, and we are going to deal with the topic leading cases as one of the subjects for AOR examination. They have got revised leading cases till up to 86 cases. So now we are going to deal with the serial number 82. The name of the case is, please note down dear friends, Mineral Area Development Authority. Mineral Area Development Authority and another versus Steel Authority of India. Steel Authority of India and another. This is the name of the case. And it is reported in 2024, volume 10 SEC, that is Supreme Court Cases, page number 1. I repeat, 2024, volume 10 SEC, page number 1. Dear friends, I want our AOR aspirants to listen in such a way that it is not mere a guide speaking on a topic. This is like all together sitting and reading the entire judgment, and we are going to travel step by step on how the honorable judges have arrived at the conclusion of the judgment. So we are going to travel along with the judgment, and we are going to find out questions and what are the answers and how they have reached these conclusions, what are the ratio decidendi. So I want you to be a researcher. I want you to remain as a student, to travel along with the judgment, to find out the answer, as how the child has a curiosity to find out what is going on. So you have to find out what is going on in the judgment, in the minds of the judges, right? So we are all going together, traveling together to understand this case, dear friends. How am I going to deal with this topic? The judgment is running to 393 pages. But AOR examination is only for 3 hours. And this question might be one of the questions. Therefore, you can maximum allocate 30 to 35 minutes. So what is the essence that you are going to write in the AOR examination to convince the examiner that you have learned this leading case? So 35 minutes will determine your knowledge and experience with respect to this case is concerned. So whatever we are going to write, we should write very, very vital points, core subject matter that has to be discussed. So that is what we have endeavored to do so, dear friends. So whatever I say, please note down and go home and read it, right? So I am going to divide this topic into these headings, dear friends. Number 1, background of the case. This is what we are going to approach. Background of the case. Number 2, issues for consideration before the larger bench. How many judges? It was decided by 9 judges bench. So what are the issues, or what were the issues before the 9 judges bench? Number 3, third heading is, what was the decision of the Supreme Court? What was the majority view? What was the minority view? That is the third heading. Fourth heading is conclusions arrived by the majority. Conclusions. Number 5, ratio decidendi to those conclusions. If lordships have arrived at particular point, what are the reasons to reach at that particular point? That is what ratio decidendi is. That is number 5, dear friends. And at the end, I will summarize the entire judgment also. So under these headings, we would be dealing with this topic. Hope this is clear, dear friends. Now let me take you to the background of the case. What was the background of the case? How the matter reached the 9 judges bench? So everything I will tell you in summary now itself, and let me take you to all these headings later. So you must always remember that this is the issue about whether state government has power to levy tax or not. Whether state government has a power to levy tax on mineral rights, or whether such right, state's right, can be curtailed by the parliament, right? So it is an issue between the center and the state to whether to levy tax on mineral rights or not. Who has the power? So when this question arose before 7 judges bench, India Cements Limited, I will give you the citations later. India Cements Limited versus State of Tamil Nadu. This case was decided by 7 judges bench of the Honorable Supreme Court, where they have held that royalty is a tax. Royalty is a tax. But that view was clarified by the subsequent judgment. State of West Bengal versus Kesoram judgment, that was comprising of 5 judges. 5 judges have held that there were some inadvertent error in deciding the India Cements Limited. So royalty, as said by India Cements, royalty is a tax. That is not so. That was held in Kesoram. So therefore, in other words, Kesoram judgment says that state has the power to levy tax on minerals. So when the state has the power, once it is declared by the 5 judges bench, the state governments like state of Rajasthan, state of Uttar Pradesh, state of Bihar, they have levied tax, environmental cess, health cess, local cess, they started imposing tax. That was challenged before the various high courts on two grounds. First ground was that state legislature has no legislative competence, that they cannot levy tax. It is vested only with the parliament. That was one of the submissions. The second submission was that such amendments or such enactment by the concerned states are violative of 7 judges bench decision in India Cements case. So these were the challenges, dear friends. And High Court, they have relied upon India Cements Limited because Supreme Court 7 judges bench judgment binding on the High Courts. So the matter reached the Supreme Court before the 3 judges bench. Thereafter, they refer to the 9 judges bench. Why? Because 7 judges bench, India Cement Limited, the correctness has to be tested by the larger bench. So when 7 judges bench judgment has to be tested, it has to be 9 judges bench. So this is how the matter traveled to the 9 judges bench. And ultimately, the 9 judges bench, the decision was 8:1. 8 judges on majority view and 1 minority view. Majority was authored by Honorable the then Chief Justice Dr. D.Y. Chandrachud, my Lord, has written on his behalf and on behalf of 7 other learned judges. And minority view authored by Honorable Justice B.V. Navaratna, her ladyship has authored a minority view. So minority view we will be discussing in the upcoming sessions. So now today we will be focusing only on the majority view. So they have ultimately held, they have overruled India Cements Limited. Why they have overruled? Because according to the majority view, royalty is not a tax. Royalty is not a tax. Number 2, state has the power to impose tax on minerals. They have got the entire power. Legislative competence is vested with the state. Parliament, though they can impose limitations on the state's power by authority of law, the law was enacted by the parliament, that is MMDR in short, Mines and Minerals Development and Regulation Act 1957. In that act, the Honorable Supreme Court has found that there are no provisions in Mines and Minerals Development Regulatory Act that restricting the state's power from imposing a tax. So therefore, though Parliament has power to impose any limitations, but by virtue of the act, there is no such provision restricting the power of the state government from levying a tax. Therefore, state government has competence, legislative competence to levy tax. While discussing this, they have asked, they have found what are the distinction between, what are the differences between royalty and tax. Right? So royalty means what? When a company, for example, let us consider India Cements. I am just giving you an example. India Cements wants to extract minerals from particular land, say in state of Tamil Nadu. They cannot go with laborers and they cannot start extracting the minerals, dear friends. That becomes encroachment. So what they need to do is, they need to seek permission from the state of Tamil Nadu. That permission has to be granted by the state of Tamil Nadu. So therefore, that concerned company must enter into a lease agreement with that particular state for a particular period, how much they can extract. So everything will be agreed between the parties. What is the benefit that state is getting by letting the party to mine and use the minerals? They get royalty. That means money, captioned under the name called royalty. For example, dear friends, easy to understand that when we are residing in a rented premises, landlord is there, tenant is there. Tenant, if he wants to reside in landlord's place, he has to pay rent. Similarly, if a company wants to extract minerals from the leaseholder, that is the state, they need to pay royalty. Money has to be paid. So royalty is a consideration in the lease agreement, right? So therefore, royalty is not a tax. So then what is tax? Tax means tax has to be levied by the state by an authority of law. For example, when income tax assessees, when they need to pay income tax, after the ceiling limit is over, then it has to be paid by virtue of the act, not by virtue of the contract. So tax has to be levied by the state by exercising their sovereign power. When a state is imposing a tax, it is exercising a sovereign power. Whereas in the royalty, they do not exercise a sovereign power, they exercise only their contractual rights. Therefore, this is what the royalty is, this is what the tax is. Therefore, royalty is not a tax. Thereafter, what is the logical end is, state has the power to levy tax. Parliament has no, though they have got power to impose limitations, but still such limitations are not found in Mines and Minerals Development and Regulation Act. So therefore, state government has power to impose tax and receive tax. So this is what the entire case is all about, dear friends. So ultimately, the answer to the question is, state has the legislative competence to levy tax and receive money, whereas the parliament, they do not have power to impose limitations on the state. So this is what the entire case is all about, dear friends. Having understood this, the summary of the judgment, let us keep this summary of the judgment as a guiding light. Now, based on the guiding light, I will invite each one of you to read along with me what is the background of the case, then issues, and then conclusion and reasons to the conclusion. Thank you so much.